All persons having business before the Honorable Chief Judge and Associate Judges now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Right, good morning and welcome to the District of Columbia Court of Appeals. Thank you for your patience this morning. We've had to transition between panels for the two cases set today. Before us at this time is District of Columbia Department of Corrections et al. Versus District of Columbia Department of Employment Services. Our counsel and parties ready to proceed at this time. Let me digress for a moment and introduce our panel today. I'm sitting with Associate Judge Roy McLeese of the District of Columbia Court of Appeals and Associate Judge Carmen McLean of the District of Columbia Superior Court, who is sitting by designation with us today.
Good morning, Your Honor. And yes, we're ready.
All right, Ms. Pittman.
Good morning. May it please the court, I'm Lucy Pittman on behalf of the Department of Corrections and the Office of Risk Management. I would like to reserve 2 minutes for rebuttal. For 28 years, Ms. Atkins has received temporary wage loss benefits, even though her treatment has remained unchanged and she has not improved for years. It is undisputed that she is at maximum medical improvement, which is a key finding in workers' compensation law that signals the end of temporary benefits. But the CRB, the Compensation Review Board, erred when it dismissed this undisputed fact and reinstated those temporary benefits. The CRB, yes.
If I could jump in with a few questions just to make sure I'm understanding the district's argument. I know you rely on the maximum medical improvement language from the regs, but I'd like to take you back to the statute first, which says, and I'm looking at 623.24D1, and it says a change of condition under subsection D4 states that benefits, quote, may not be modified because of a change to the claimant's condition unless one of 5 categories of change applies, including when the disability for which compensation was paid has ceased or lessened. That's one of the 5. And then the others are the disability condition is no longer causally related to employment, or the claimant's condition change from total to partial disability, or the employee released the employer released the employee to return the duty, or the mayor determines that there was some error. I think those were the 5 conditions, paraphrased more or less. And I guess I don't see how Ms. Atkins fits into any of those categories.
Sure. It's our position that she fits under category A, which is that the disability for which compensation has paid has ceased or lessened. And it's the ceased language that I'm going to focus on.
Yeah, that seems counterintuitive to me. If something goes from temporary partial to permanent, that seems to me to be an increase, not a ceasing or lessening, but open to hearing your thoughts.
Sure. I think we have to read that provision in context of 0.07 as well as the CMPA in the total. So 0.24 is really about initial claims and temporary benefits. You wouldn't have a situation, for example, where someone is on a permanent benefit that would need a modification. So 0.24 does not apply, 0.24D does not apply to permanent disability benefits, because you just would not have a modification there. And I think that is underscored by 0.07, which says, using very similar language, it mirrors the language of ceasing, that the temporary disability benefits, the compensation must cease before you can get a permanent.
Right. But how do you square that with 623.06A, which which seems to contemplate that exact situation where there's 500 weeks of a cap on benefits, and that within the last 52 weeks, and as I calculated, Ms. Atkins is or was at the time of this claim within the last 52 weeks, she can petition to change from temporary to permanent disability. I don't understand the artificial jumping in and it's abruptly terminating her temporary benefits when this provision exists to allow her to transition to permanent disability.
Sure, and I'm going to respectfully push back a little bit on it being an artificial termination. 0.06A contemplates that the individual who gets to 500 weeks still has a temporary disability. It starts by saying for any one injury causing temporary total or temporary partial disability. Here we know that she does not have a temporary disability. It's undisputed that her disability is at permanency. And so
I'm not sure I follow your point about 0.06A. It seems as though it contemplates someone who currently has a temporary award and who's running up against the cap for temporary awards, who may or may not be able to show entitlement to a permanent award. And if they can, then their payments will continue and they'll kind of shift over to a permanent award. It doesn't seem to contemplate someone who definitely, because I mean, if it's someone who definitely is still in a context of having a temporary award, there'd be no need to shift over. You wouldn't be able to show that they're entitled to some permanent award.
So again, I'm going to push back a little bit on that, because I do think specifically when the cap was added, it was to address the individuals who were still in a temporary disability status, which is what
For sure they're in a temporary status. Correct. In the sense of what they're being, what their current award is and what they're being paid for. But the idea is someone's in a temporary status. No one is really necessarily, the claimant at least is going to be happy with that going on indefinitely, perhaps, unless the claimant perceives it'd be better to convert to a permanent award, which maybe the claimant would. But in any event, if that's running on and we're getting up against the end, the statute seems to say, okay, let's figure out what the real situation is. Either they're going to just lose all benefits where they're going to run out, or they're going to show an entitlement to a permanent award. We don't really know which they'll be able to do, and that's why we'll have a hearing and we'll figure out which of those two things should happen. Is that not what you think it's intended to address?
No, I don't. I think that the use of the word temporary benefits there signals, and again, reading it in conjunction with 0.07 and 0.24, the idea being that when a claimant's change to their medical condition goes from recovery to stabilization, which is what maximum medical improvement is, and their condition is no longer temporary but permanent, that they should be moving off of the temporary benefits into permanency. And I'm going to add to the statutory discussion 0.04, which is vocational rehabilitation. Vocational rehabilitation does refer to the maximum medical improvement. And what happens is the idea is that you are removed from your temporary wage loss benefits when you reach maximum medical improvement. You then are given vocational rehabilitation, which still augments and provides you with wage loss benefits, but for 90 days to up to 1 year, in which then permanency could be determined. I also think that the 500-week cap was not intended to be in addition to 0.07. And so for a lot of these individuals, because 0.07 is the schedule, right? And so, for example, there has been a legislatively determined that if, for example, you lose the loss of your fourth finger, you get 15 weeks of compensation, not 500 weeks, which is close to 10 years plus the 15 weeks of compensation. I think it really undercuts that schedule.
Back to your point about the language of 0.07.
Sure.
And you were pointing out accurately that 0.073 A3A also uses the word cease, which is the word that's in 0.24 D4, but it's used in a different way. The language in 07 is if compensation has ceased. And 24 is whether the disability has ceased or lessened. And so I don't, those seem like the statutes are calling for quite different inquiries into what has ceased.
Sure. I think that point 24 is read as it's the disability for which compensation has been paid has ceased. I'm going to fully acknowledge, I think this would.
Well, no, but just to be grammatically, what the word ceased modifies is disability. If the disability has ceased, you agree that that's grammatically what has to have ceased under the rest of it tells you which disability you're focused on, but what has to have ceased under 24 is the disability. Do you agree with that or disagree with that?
I think that it would have been better written had it said the temporary disability for which compensation has ceased, if the word temporary had been added. But
my question is a grammatical one, though. So just my question of grammar. When we're looking at 24,
yes,
whether the word ceased refers to the disability, so the disability must have ceased or lessened.
Yes, I should have started with yes, I agree with you, and then
just in
proceeded to say that-
contrast, you agree that under 07, what has to have ceased is compensation.
Correct, and that is where that is the point I was trying to make, and I apologize for not starting with the yes. I should have, yes, but I think the reason why point 24 D4A is read as temporary disability has ceased, and I think the temporary has to be there is because we do read this in context. It is not a permanent disability has ceased. That's not a possibility, and you would never be proceeding to modify a benefit for a permanent disability. And so point 24 is in reference to a temporary disability.
Is that not right? I mean, if there's a determination, there was a permanent disability award, and while it's still being paid out, the program ends up deciding, you know what, that was in error. Well, we thought it was going to be permanent, and all of a sudden, to everybody's surprise, there was a determination made, maximum medical improvement, this is a permanent award, and then all of a sudden, the person is cured and everything is better. Are you saying that that these provisions don't allow a modification because what was thought to be a permanent disability is now understood to be no disability at all?
I don't see that as being a mechanism under 24.
Can I ask you a practical question about how this works?
Sure.
So imagine that I am a claimant and I was determined to have a temporary disability, and I have been receiving temporary disability payments. And I'm not near the end, the cap, so those provisions aren't available to me at this time. And either the program thinks no longer temporary, and therefore, the program tries to terminate me. Or I say, I think I would like to get converted over to permanent. I think I've reached maximum medical improvement, and I would like to convert over. I don't know whether that would ever be my interest, but assume for a moment I think those things. Am I right in understanding what you think has to happen is, although even if it's true that substantively I'm entitled, if I could show that this is what was giving me temporary benefits now entitles me to permanent benefits. So there shouldn't be substantively any interruption in my benefits. I have to either get terminated by the program and get no benefits for a while, and then I have to apply and try to get permanent benefits instated. Is that right? Is the consequence of the approach reflected by ORM's interpretation and maybe by its regs that there's going to be, for people who substantively really should be getting payments all along, a kind of a mandatory hiatus where while they're fighting about the transition, they get no payments?
No, there should be virtually no gap in most cases. And so if you can bear with me, and I'll explain the process. So first, in order to have the temporary benefits terminated, there still needs to be a finding of MMI. It can't just be that you want to convert to permanency. There still does have to be that finding. So that's first. So under point 24, we would terminate temporary benefits because of reaching MMI. The individual would then go on vocational rehab, where they would continue to get wage loss benefits under point 04. Those are for 90 days up to one, but it can be extended up to 1 year. And the request for a schedule award is directed when we terminate benefits. Those decisions are generally made within 30 days. It can take longer if a disability rating has not been found or something like that, but generally speaking, 90 days is sufficient time for that to occur. So for the vast majority of cases, there will be no gap in that situation. I will caution you, and that was not what happened here, because this is a case that has been on temporary benefits for close to 3 decades. And so, for example, 0.04 and the vocational rehabilitation when you reach MMI is something that came into the statute in 2010. And so if, for example, you've already had vocational rehab in the history of your claim, you won't get it again. There could also be the potential of someone who doesn't have work capacity who maybe won't go to vocational rehab, although there is the regulations contemplate that an individual can seek and start the paperwork for permanent disability earlier, so that there shouldn't be a gap in coverage. Although I will also say that schedule awards determinations are made largely, the last stat I saw on that was about 90% within 30 days. And so to the extent that there is concern of a gap, I think that the statutory language eliminates that for the vast majority of cases where claims have been filed in the last 10 years. And the regulation also tries to really close any gap as well.
Can I ask you a flip side of that, which is one of the lines of argument that ORM and DOC have been making is if the statute isn't construed in the way that you're advocating, it'll just be absurd. There'll be like a big gap in the statute and it won't make sense. And I'm not quite sure I understand that exactly. So it seems like that might need to be explained more. So imagine I'm an employee / claimant, and I've got a temporary award, and I'm going along getting a temporary award. And let's say the district's view is, or ORM's view and or the employer's view is that I've reached maximum medical improvement, and therefore I could permissibly be converted to a permanent scheduled award, and permanent scheduled award, let's say. So why is it a problem that if it is one, that there isn't a mechanism, if there isn't one, for the mayor to come in and say, okay, go ahead and convert? Is it that it increases the amount of payments to an unfair amount, or why is it a problem if the payments continue on a temporary basis instead of on a scheduled basis?
Because it does result in a significant number of overpayments. And I think the example I started to give earlier, where we've got a legislatively determined number of weeks that, and I think the example I used was fourth finger was lost, that's 15 weeks of compensation. I think if we do not allow for termination of temporary benefits when an individual reaches maximum medical improvement, and then put them on to a schedule award where they get 15 weeks of compensation or up to 15 weeks of compensation, and instead leave them on temporary benefits, you end up with close to 10 years of temporary benefits, despite the fact that the individual does not have a temporary injury. And I think that really undermines the schedule.
Ms. Pittman, I guess I still have to go back to my earlier question, because you seem to suggest, I think at one point, that this kind of leads to an absurd result, so to speak. But I think that the statute and the statutory scheme build in a safeguard in 623.06A. As I asked about before, here, if we start from the time that Ms. Atkins' benefits were reinstated in 2011, she hasn't yet, or I guess even if we total them all together, I don't know that she's reached the 500-week cap, but certainly from 2011, when her benefits were reinstated, to now, she hasn't yet reached that 500-week cap. She's within the period of time, those 52 weeks, where she can petition to seek to be transferred to the permanent disability payment scheme. So it seems like the statute contemplates that. And it also seems like the regulations contemplate that. You rely on 199, DCMR 199.1, maximum medical improvement, but DCRM 140.1 says that a claimant who reaches maximum medical improvement may be eligible for permanent disability compensation. It doesn't say that the claimant who reaches MMI is no longer eligible for temporary disability payment. So I don't think, certainly take your point that we want to avoid overpayments. But we also want to make sure that we are adhering to the overarching or underlying purposes, humanitarian purposes of the statute here. And it seems like the statutory and regulatory scheme build in the safeguards to avoid the concern that you have here. And why not let Ms. Atkins go through the process in 623-06A within that last 52-week period to request a transition to permanent disability. I guess I don't see anywhere where it says the district must terminate temporary benefits. And that's what I'm missing in your argument. And please redirect me if I'm not seeing that as I try to weave through all these regs and statutes.
Sure. So I have a couple of things. I'm going to start with your question on 0.06A and whether that's a safeguard. That was put into the Act in 2010 under the backdrop of there being too many claimants on temporary benefits for too long. So it's a mechanism for actually processing these claims out that should have been processed out a long time ago.
Right,
it's
which
not
is exactly
really
where Atkins falls. And then right after this change in 2010 is when her benefits, I guess, were reinstated again in 2011, if I'm not mistaken.
So there's additional changes that were made to the CMPA, also directed to try to process these claims so that claimants do not remain on for decades. So the 0.04 change is also one of those. These were not intended to leave people on for 10 years who shouldn't be. It's just a mechanism for processing them out. And it's more of a safeguard of, if you can't process out earlier, then you have a 500-week cap as the ultimate decision point, but they should be processed out earlier. The reference to the may in the regulation, I think, just requires me to explain what MMI is and why you would get permanent award versus not. So maximum medical improvement simply means that you have reached a point in which you will not improve over time or with additional treatment. And it's a predictive standard that doctors project, but it doesn't mean equal permanency. And so there's case law on that as well. So for example, if I sprained my ankle and I return to baseline, I'm at maximum medical improvement and I do not have a permanent disability. So I would not go on to a schedule award. I would simply just stop getting my temporary benefits. So that's why the word may is used there, is that every person who reaches maximum medical improvement doesn't have a permanent disability.
Right, I get that.
They could return to baseline.
Right, so Miss Atkins, that determination could be made for Miss Atkins that her injury is permanent. If you, depending on which of the experts you credit, at the time that she requests within that 52-week period to obtain permanent benefits. So she may be eligible for permanent disability, she may not be, but the provision is there. And I'm waiting to hear from you the parts of the regs or the statutes that say the district must terminate someone from their temporary disability benefits when they're still within this 500-week time frame.
I don't know that I can point you to a provision that says that it must occur. I think it falls into the ORM is obligated to implement the statutory scheme as it stands, and it cannot just leave people indefinitely on temporary benefits. There's reference.
But you won't be. I guess that's the part I'm puzzled by. Ms. Atkins will not forever be able, under the statutory scheme as it stands, to stay on temporary disability benefits. She isn't that correct? After this 500-week period is over, can she continue to stay on temporary disability?
No, but again, those are only supposed to be for individuals who are still in a temporary status. And so for individuals who have already moved out of a temporary status because they've reached maximum medical improvement, the statutory scheme isn't designed to just allow people to linger for 10 years receiving benefits.
Can I ask you, I want to make sure I understand how 06A applies to the claimant here. I thought you said she had been receiving temporary benefits for decades.
Yes. Well,
so that's more than 500 weeks. And so I had been assuming, but I realized I was just trying to check and see if I could quickly verify this assumption, but I've been assuming that maybe she was not subject to the cap because it's got a provision that it doesn't apply to employees who were hired before 1980, but I don't know whether she was or wasn't hired before 1980. I know her injury was 93, but I don't remember her date of hire. So if this provision, if she's really been receiving temporary benefits for decades, then I don't understand how this provision hasn't already kicked in. So what am I missing?
So it's my understanding, first I'll start with subsection C says that it applies 1 year after September 24th, 2010. And so the way in which ORM has interpreted that provision is that they started the 500 weeks for individuals who are already on claims in 2011. So that meant that her 500 weeks ran in April of 2021. It's my understanding from Mr. Levy's brief and from talking to the program that she has requested a hearing. And it has not been held with regard to that. But I just want to underscore.
Can I ask you about the interaction between these? So if she's subject to this provision and that's going on right now, imagine that what is contemplated in 623.06A is started up. So there have been 448 weeks of compensation or more, and the claimant has requested a hearing for purposes of determining whether there's a permanent disability or not. Can the program, relying on the regs, instead just say, no, we believe, and there's a medical, there's medical support. We have reason to believe. It shifts over a little bit to the burden of proof question, but we have reason to believe that this is permanent, so we're terminating right now.
No,
once the process starts under 06A, is there no ability to terminate? And instead, there's like a seamless transition where during the period where this is all getting litigated administratively, the temporary benefits continue.
So the idea, I'll start with, they do not terminate when someone is in that last 52 weeks, because if they've requested a hearing, because then it's before OAH. And so they don't view that they really have that would be their role at that point. But that is because if things had been going well, that means that individual has not reached maximum medical improvement, because if they had, they should have been terminated earlier from temporary benefits. And so, I realize we've been talking a great deal more about plain language. We do have a deference argument with regard to the statutory interpretation. I don't know if the court would prefer that I transition into that, or if we would like to talk more plain language of the statute. I am mindful. I know I'm at 0 on my clock already. And so we do have, it to the extent that there is an ambiguity. And I think that the discussion I was having with Judge McLeese about the fact that I think 24D would have been better understood if the word temporary was before the word disability. I think context says that it is there, but certainly it is not in actuality. And so ORM's interpretation must be deferred to as long as it is reasonable and it doesn't misconstrue the law.
And when you say, can I ask you, in the past, when we have been deferring to the CRB, and we've been deferring in settings where the CRB will then write opinions and explain its reasoning. And if we're deferring to ORM regulations, then we don't always have so much, an explanation provided in an adjudicatory way like we're more used to in these workers' compensation cases. And so what we do have instead is a brief, I guess, and there's questions about when you defer to agency positions articulated in briefs, especially briefs filed not only on behalf of the policymaking entity, but also on behalf of the interested employer. Or we have, I guess, maybe when these regs were promulgated, there may be like notices of proposed rulemaking and the like and rationales. Where would I find, if we were trying to figure out, well, does this make sense? And we were worried about things like, well, this is a humanitarian statute. Is it going to create gaps? So there are people who are really substantively entitled to benefits who are going to get tangled up in these procedures in a way that doesn't make sense. Where would we find an explanation of all of that would lead us to think, okay, these regs are reasonable? Is there someplace? I haven't actually yet gone back to look at the notice of proposed rulemaking relating to the ORM regs, some of which are at issue here. Is that a place I should go? And if I do, will I find an acknowledgement this is a humanitarian statute and indication of concern to make sure there aren't unwarranted gaps in the award of benefits and the like?
So there is in the preamble to the final rules an explanation as well as responses to comments. You will see in those comments that changes were made to try to make some more flexibility in certain places, I think to reflect the humanitarian nature of the act, as well as explanations as to why these various provisions are more closely tied to the CMPA than what the procedures were previously. I don't think you can discount as well, though, the decision here in this case, which also reflects their understanding of the CMPA, which is that termination at MMI for temporary benefits makes sense, and then an invitation to seek a permanent award. And I also think you see in the regulations themselves their interpretation. It's not uncommon in a lot of regulatory schemes for the interpretation of the various provisions to be in those locations as well as in briefs and litigation. And I know that post hoc rationalizations are not favored, but just because it's in a brief doesn't make it not their interpretation. And I do think that ORM's interpretation here, which is their attempt to piece together what is, I think, a complicated set of statutory provisions, and they try to give meaning to all of those provisions. It tries to avoid a result of individuals who have reached maximum mental improvement. Their condition changed to stable, and transitioning them, I think, responsibly. It's consistent with Larson's, which we know is the treatise on all of this. It's even consistent with some of the private sector cases.
I know I've been in a series of cases in this area, so you probably know, and it's not entirely clear to me that ORM's view of some of these statutory provisions has been consistent over time, at least in litigation. And so I want to make sure I understand back on D4. Mm-hmm. Is it ORM's view that a modification is permitted under that statute only if there is a change to the claimant's condition?
So the phrase change of condition, I know has been argued about pretty extensively. In this case, there is a change to the physical condition, which is that it goes from a period of recovery to a period of stabilization, and that's a medical determination on the claimant's condition. So here we do have a change in physical condition or a change to the claimant's condition sufficient to reach the point 24 language there.
I was hoping you'd wrap back around to my question, though, which is ORM's view that a change in condition a change to the claimant's condition is required?
I don't know that I can answer that in all cases. I think that generally, yes. I think that has been their general position. I hesitate because I think subsection E of 4 doesn't actually relate to condition. And so I do need to be mindful of the statutory language itself kind of goes the other direction. So I don't want to go too far on that, but certainly here.
And just do you at least understand one reaction to the argument that this is a change in condition? It almost seems 180 degrees opposite of a change of condition. There's a condition and everybody's thinking, well, maybe it'll get better. And then a determination is made, you know what, that condition is never going to change. To call that a change of condition seems almost, the opposite of what it is. It is a determination that the condition is not going to change.
I understand that. I think probably, the man on the street would probably say that would agree with that. I just think that in workers' compensation, it is a very specific kind of finding. It is a key finding. And you read that in Larson's and you read that in other cases, that it is the change to the claimant's condition from a period of recovery to a period of stabilization. And so I know that it feels weird to say that, but I think in workers' compensation, that is the right answer.
So I have a question other than E, which obviously does not relate to the condition in the same way. A through D all discuss, unless you read the word ceased as you would like us to, they all discuss decreases in the problem, the decreases in the disability, or that they're able to return to work. They're consistently all changing in that direction. And you would read ceased to be the absolute opposite of every other part of these subsections.
No, I'm going to push back a little bit on that because I think what point 24D is designed to do is to make sure that a claimant who is having a reduction or a termination of benefits, which termination of temporary benefits because the condition is no longer temporary is A, gets the notice and the hearing that's required. And so I think that's what it's designed to do. And I don't see this as being in opposite of that because it is a termination of temporary benefits where you do want to make sure that you provide adequate notice and that you get a hearing as contemplated in subsection F. And so I think we also need to be mindful that here a modification of benefits is initiated by the mayor. That's different than in the private sector where an initiation of modification of benefits can be by any party. And so it could be a potentially increase of benefits. Here, we are actually talking about a decrease. We are terminating temporary benefits. It's not an automatic that she gets permanent disability. As I was explaining to the chief judge, there are going to be times where it's a termination of temporary benefits because you've reached maximum medical improvement, you've returned to baseline, and you don't get any more benefits after that. And so it's really more of just making sure that individuals who have their benefits terminated or reduced have notice and a hearing.
Can I ask you, if I am receiving temporary benefits and I'm not in the last 52 weeks of the cap, and I decide, and I don't know whether it would or wouldn't, maybe it never would be, and that may be the answer. Let me ask it this way. Would it ever be in my interest to say, you know what, I would like to get a permanent award? Or is it always, that would never make sense because that just then starts a clock terminating your benefits? Or the only reason I ask is because it doesn't seem, if you're right, that modification under this statute can only be done at the behest of the mayor, which is how it's worded. That's certainly true. Are you saying that there's no way for a claimant to come in and say, yeah, I was temporary, but now I am not. I'm permanent, and I think it's time for a permanent award. The statute, in your view, doesn't contemplate the claimant doing that?
I don't believe the statute does, but the regulations have provided for that because there are claimants who do want to transition out, and the program has described those that they do get requests for schedule awards while individuals are still on temporary benefits. And so section 140 of the regulations does allow a claimant who has reached maximum medical improvement, who's just ahead of the program, to go ahead and apply for. But there will be a finding, there does need to then be a finding of maximum medical improvement and a termination of benefits before any sort of permanent award can then be issued. And so there have been circumstances where claimants do that.
Your view is that if the regs authorize that as a modification, they're not right, I thought, because you were just saying that the regs contemplate modifications only at the statute contemplates modifications only at the behest of the mayor.
Yeah, it doesn't get viewed as a modification, and they don't have a hearing on that because they're the ones who are requesting it. And so it doesn't fall into that category. It's something that's contemplated that an individual can, when they reach maximum medical improvement, initiate this. It reduces the gap to the extent that there would be a gap for anyone prior to 2010.
Right, Ms. Pittman, if you could, I know we've taken you way over your time with our questions. This has been a very helpful discussion, but I would like to hear from the intervener, and we have also reserved some time for your rebuttal.
Sure, I haven't said anything about argument 2, and so, but I understand we're over time, and I just wanted to reference it.
We would like to hear from you on argument 2. We spent so much time with our many questions on your argument 1, but I will give you additional time, and thank you for bearing with us, Mr. Levy. We'll allow you some flexibility with your time as well. Ms. Pittman? Ms. Pittman, did you want to briefly address your second argument?
Sure, absolutely. So the burden of proof standard, we have a validly promulgated administrative regulation, which has the force and effect of law that provides a burden of proof standard for modification of benefits. This is within ORM's power under 0.02A of the CMPA, as well as 0.44, that they are in fact required to issue rules on the modification of an award of compensation in the conduct of hearings under section 1.24. To include a standard of review applicable. Admittedly, this is a different standard than what has been used since about 2014, which was a standard that was created in Mahoney, a CRB en banc decision. In order for for ORM to change a standard like that under this court's case law, they're obligated to explain why this new interpretation is more closely aligned to the statutory language and legislative intent. They did so in their final rulemaking. They have an explanation as to why this two-step burden with the ultimate burden of persuasion on the employee is more closely aligned with the CMPA. I'm happy to go through that. It is in our brief. I am mindful of time. And so
I have gone and looked at that. And if I recall, there are kind of 3 points. The first 2 are more defensive points, which are we're not bound by what the federal folks do because statutory language is different, and we're not bound by Mahoney/Ross. So the only kind of affirmative point is, well, there's the statutory reason to believe language, and that suggests something less stringent. Although, if I recall correctly, what ORM says in that notice, either the notice of proposed rulemaking or the final rulemaking or both, is that the statute requires the mayor to modify if the mayor has reason to believe. That seems to me incorrect. Do you agree that's incorrect? Because what the statute says is that the mayor may modify.
Double checking, that's my memory, is that it is may as well.
I guess so that, really there's one affirmative reason that seems incorrect in one respect. And there really isn't any discussion of the countervailing considerations, which were the ones that the court found persuasive in Ross when it approved what the CRB had done. And at one point referred to what the CRB had done as the proper interpretation of the act, and also did say that the act was, I think, silent. The language of this act was silent, although the act was in its current form. So I guess ORM, or at least your argument, is that the court was wrong in Ross to say that the language is silent, because ORM's analysis is actually the language is the only reason we're giving, the only affirmative reason we're giving for our outcome. But there are also just some things missing, like where's the discussion of, well, on the other hand, it's true that ordinarily people who are trying to change the status quo bear the burden of proving it, and this is a humanitarian statute. And so if we were looking at it like a typical agency, CRB decision in an adjudication that gave all the reasons for a conclusion, I have to say it seems like there's a fair bit either incorrect or missing about it. So I wanted to give you a chance to react to that.
So a couple of things. I'm going to start with, while the act is phrased as the may or may modify, it is based upon a reason to believe that a change of condition has occurred. And I think that the obligatory language, while perhaps inartful in the preamble to the final rules, is that is to the extent that there is anything in the CMPA to sort of signal what it is that initiates a modification, that is the language. We don't disagree, as this court found in Ross, that the CMPA is silent on who holds the burden of proof for modifications. That silence means that there needs to be an interpretive decision by an administrative agency. So I would also I would also just
there for one thing. If you agree that the statute is silent, it seems to me that you're agreeing that ORM's reasoning is incorrect, because ORM says the reason we are doing this is because there is this language which signals a lesser standard of proof. So it seems like that may have been imprecise wording on your part, but if you agree that the statute is silent, it seems that would be bring into serious question the ORM's reason.
So I just want to add a little bit to I wasn't quite done. So I agree with you that the reason to a reason to believe a change of condition occurred itself is not a burden of proof, right? It doesn't say who holds the burden of proof. It indicates how you initiate the claim. And I think that they are right, that is the correct thing that you would then apply as perhaps an initial burden on the employer. But I think that they also added that the DCAPA has been carved out of these hearings. And I think that that's also important, because the DCAPA has a burden of proof. The burden of proof we more commonly think of, which is the person who's moving bears the burden of proof. That also signals that the council did not necessarily intend that the burden would be sort of the run-of-the-mill normal burden. And so it could be as Mahoney did it, but it could be that it's not. Both can still be reasonable interpretations of the CMPA. And so I don't think that the preamble is short on talking about the CMPA itself, because I do think that the DCAPA being excluded is an important factor in this determination. And I also don't know that I would agree that the discussion of the federal and the private sector are completely defensive. So in both of those, the burden of proof is on the employer, but that's because those statutory language in both of those situations are very different. The federal statute does not have an equivalent of 0.24D. That was something that was added. Most of 24, I think, I'll rephrase that. 0.24D was added by the council. It was not in the federal act. And the private act is very different in terms of modification of benefits. It too does not have a similar list as 0.24D has. And it can also be, a modification can be initiated by any interested party. And so all of those things signal that the statutory language here may not be that you have the normal burden of proof that perhaps you would have in some of these other statutory schemes.
Can I ask you a question? You at one point you referred to the intent of the council, which is certainly a relevant piece of the inquiry. And at least when I went to find the legislative history relating to the enactment that added the reason to believe language, I didn't really find any explanation that tied into burdens of proof or any indication that it was a significant, it was intended, that language itself was intended to achieve any particular significant purpose. And one could wonder, I guess, one could say, it's a humanitarian statute. If, ordinarily people, if someone has been legally determined to be entitled to something, and then someone else wants to come in and say, you know what, they're not entitled to it anymore. ordinarily the burden would be on the person who's trying to change the status quo. And if the legislature was trying to shift that around to say, you know what, in a particular context, we are trying to allocate burdens in what is a somewhat unconventional way, not what you'd be, or not what you would ordinarily do, much less ordinarily do in a humanitarian statute. You might think that the legislature would have somehow communicated that that was what was intended. Is there anything in the legislative history that you're aware of that suggests the council had in mind a change of that kind?
Not in the legislative history, no, but I do take that the flexibility that they added to point 24B, where they say that the rules of evidence don't necessarily apply and some of the other procedures don't apply. They could have left it at that if the goal was just to have flexibility, but the removal of the DCAPA and its burden of proof, I think signals that they left for the administrative agency, which it then charged in point 44 to develop these standards. And so I think it does leave open that a reasonable interpretation can be that the burden of proof is on the employer. And we do need to be mindful. This court's case, there's a WMATA case that was cited in the brief from 97 that does talk about the fact that in workers' compensation, the burdens of proof may not be what you would have in a normal run-of-the-mill case. That's makes sense because frequently it's the claimant who is in the best position to produce evidence in their cases. They have their full medical history. They know the treatment that they're getting outside of the program. The program does not know about that. They know about their ability to work, their efforts to work. And so I think all of these support that this is a reasonable interpretation of an act that is otherwise silent on what the ultimate burden of proof would be in this case.
Right. Pittman, I'm going to stop you there. Thank you.
Thank you.
And we'll reserve a few minutes for your rebuttal as well. Mr. Levy?
Yes, good morning, Your Honors. May it please the court, my name is Harold Levy, and I represent intervener Alma Atkins. Your Honors, logic and the District of Columbia law both dictate the result here. When a workers' compensation claimant whose work disability transitions from temporary disability to permanent disability, as ORM admits Atkins' disability did transition, the claimant's disability benefits should transition from temporary to permanent as well. Instead, what risk management did is that when interveners' temporary disability became an acknowledged permanent disability, ORM simply terminated her wage and medical benefits. Not just her wage benefits, but her medical benefits as well in their entirety. While interveners' temporary condition may well have ended when it became permanent, her disability did not end. Her disability is permanent. It continues to this day. Terminating interveners' wage loss and medical benefits when her disability became permanent makes no sense in a rational workers' compensation program that is predicated on disability. ORM's termination of interveners' benefits, we submit, violated the humanitarian and remedial objectives of the Comprehensive Merit Personnel Act. Termination also violates District of Columbia law. Petitioner's second contention is that when ORM determined it could not meet the burden of proof regarding its erroneous terminations of benefits, it sought to avoid the unfavorable outcomes it was receiving by switching the burden of proof from ORM to claimants. We submit ORM's rule here is arbitrary and contrary to DC law as well. Permit me to return to the permanent disability issue first. ORM contends that once a claimant's medical condition, not her disability, has reached a plateau called maximum medical improvement, where one's condition is not likely to improve, and the claimant is permanently disabled, as Atkins concededly is, ORM contends that it can terminate the claimant's biweekly disability and medical benefits. Petitioners argue that once those benefits have been terminated, the claimant can seek a scheduled award under 07, despite his permanent disability and qualification for continuing permanent disability benefits. separate and apart from the scheduled award. But according to ORM, the claimant is no longer eligible to receive wage or medical benefits for their disabilities. Petitioners claim this to be the case for intervener, even though she is not even eligible for a scheduled award because the particular body part she injured, her back, is not a scheduled body part. Terminating intervener's benefits because she reached MMI and is totally and permanently disabled is not just irrational. It's not just contrary to the humanitarian and remedial objectives of the CMPA to provide wage and medical benefits when claimants are disabled because of work injuries. Termination because a claimant has reached MMI is contrary to the CMPA.
Before you get, can I make sure I understand the scope of your argument? I mean, I get your points about kind of the transition and termination of benefits during the transition, but is your point more fundamental than that? So one aspect of your opponent's argument is there's got to be some way, if there's someone who's currently receiving temporary benefits, but it isn't temporary anymore, it's permanent. And now the question should be, what kind of permanent benefits are available under the CMPA public sector provisions? There's got to be a way to initiate that and to have a determination made other than just waiting for for 442 weeks and the claimant to initiate that process. Do you disagree with that? Do you think that imagine a slightly different scheme where ORM said, we can modify in the following way. If you're currently getting temporary and there is a determination made, once it's established that you really should be permanent, if that's our view, then we will start giving you permanent. So or are you saying, look, there's just no way to get there from here? Under the statutory scheme, all that happens is if there's a temporary award, it goes on, whatever is happening, as long as it doesn't diminish, as long as it is, even if it becomes permanent, still get temporary awards until the end of the cap. Is that your view?
I agree in part, Your Honor, and I disagree in part. There are two permanent disability benefits. There's the scheduled award, and there the claimant could, having reached MMI, if it suits that claimant's interest, apply for a scheduled award. There is no such provision for permanent total disability benefits continuing once the temporary total disability benefits have ceased or ended because the claimant has reached MMI. Clearly, the statute
you say that, and I think the district has taken that view in earlier cases that I've sat on. I just want to make sure, is that something that this court has held or something that the CRB has held? Is that an established, so is it clear, you think, by determinations of this court or I guess maybe ORM regs or the CRB, that there is no longer like permanent total wage loss disability, for example? I know that I think there may well,
that has
clear.
I'm sorry. It has been ORM's argument in the past, has not reached this court yet, but it has been ORM's position that permanent total disability benefits were repealed by the City Council in 2015. ORM and the CRB have taken serious exception to that. They have said that there is nothing in the statute that was enacted in 2015 that repealed permanent total disability benefits. In fact, section 1-623.05 provides a prima facie presumption for the continuation of permanent total disability benefits.
Yeah, I don't mean to derail you. It's just that you seem to be assuming something that it wasn't clear to me is obvious. But do you agree, though, that there isn't any more under the, or whether there was or wasn't, but there isn't now permanent partial non-scheduled or permanent partial wage loss disability under the CMPA, that isn't available?
I think that issue is in the process of being determined by OAH and the CRB at this point. Yeah, I think there's a question as to whether you can request permanent partial disability benefits separate and apart from a scheduled award.
So is this
I
fair?
don't think that's clear at this point.
So is this fair? Your concern, at least, is that under the statutes that provide for partial temporary wage loss benefits, that if whatever the process is, if a determination is made that your client's situation is no longer temporary, and that's a basis for stopping to provide temporary benefits, then your client may have no further remedy because your client doesn't have a scheduled injury, and there may well be no partial or even permanent, though your client isn't arguing for permanent, I don't think, total permanent disability. Is that a fair?
I think
point?
that's a fair statement. And that's one reason why I go back to what the chief judge was asking earlier about what is in 1-623.24 D4A, which is the 5 statutory bases on which ORM can terminate benefits. One is that the disability for which benefits have been paid has lessened, not that the condition has changed. The disability has ceased or lessened. The second is that the claimant's disability, again, whether temporary or permanent, is no longer a disability that relates to his work-related injury. The third is that if ORM can demonstrate that the claimant has been released to return to work, well, that's not an issue here. Ms. Atkins is clearly permanently and totally disabled. And the last one is that ORM can terminate a claimant's benefits if it establishes
Did you say she was
the claimant's disability.
totally disabled? Did you just say she's permanently and totally disabled?
Yes, and I believe risk management has agreed that she is both permanently and totally disabled. There is no partial disability.
The physician's number was 39%, and so that it wasn't total disability. And I thought that ORM and DOC were explicitly contesting whether there is any total disability even claimed here, much less established.
I think permanent impairment as a percentage is different than work-related disability. She may have a 39% permanent partial impairment of her back. She is still able to walk on crutches or with a cane or with a walker. She's not able to perform the duties of any sort of employment given her permanent disability work condition. Those are different, and OAH in the order determined that when it rejected the IME doctor's opinion, it determined that the Office of Risk Management failed to establish grounds for Ms. Atkins' termination of her disability. The last factor that I didn't indicate is that ORM can terminate a claimant's disability if it establishes that the disability has changed from total disability to partial disability. Again, total to partial, as the chief judge indicated. Nowhere in this statutory scheme is there any provision in the CMPA that ORM can terminate a claimant's wage and medical benefits because her disability has changed from temporary disability to a permanent disability, or because she has reached MMI status.
Mr. Lev, can I jump in there? I appreciate you taking us back to these 5 factors. And I wanted to ask you how you see the interplay between the 5 factors under 623.24 D4 and 623.06A. Has Ms. Atkins filed an application? I had understood that she was or was about to file an application for permanent total disability under 623.06A. Has she done that? Or what's the status of that?
She has, in fact, done that. That matter rests with OAH at this point in time. It won't be decided until this matter is decided with regard to the burden of proof and the MMI status, because she may not have been at that 500-week level at the time her benefits were terminated. She's certainly at that level now. Right. As Ms. Pittman indicated, they calculate the 500 weeks from September 24, 2011 forward. And since then, she certainly, to the date of her term, past the date of her termination of benefits, she certainly has reached that level. So that's an issue that will have to be revisited at some later date, depending on how this court rules.
Is that how you see the statutory scheme working? Or if not, or in addition, how do you reconcile 623.06A with 623.07, which says that a claimant can only get the permanent total disability after their temporary disability benefits are terminated?
07, first of all, is a permanent partial disability award. It is not a permanent total disability award. It's a scheduled award for a partial impairment. To the 06A relates to permanent total disability benefits. And unfortunately, there is, to answer a question that was raised earlier, there is no provision that I know of for a person at, let's say, 150 weeks of having received temporary total, who is unquestionably permanently and totally disabled, to apply for permanent total disability benefits. The provisions just don't exist. However, it should be borne in mind that there's no payment difference between temporary total disability benefits and permanent total disability benefits. They get the same 66 2/3% of their average weekly wage under either program. And so it has been the case historically.
Mr. Levy, can I, before you move off your response to the Chief Judge's question, you said something in it that I wasn't sure I understood. So you seem to say that you think 0.06A relates only to permanent total disability rather than to the scheduled awards in 0.07. And I just don't see that in the language of 0.06A. So maybe you can point me to it. It ends up saying the purpose of the hearing is for determining whether the claimant has a permanent disability, which seems as though it would embrace both total permanent disability, if that exists under this statute, which I gather is disputed, and the permanent disabilities that everybody agrees exist that are laid out in 623.07.
I agree, Your Honor. I misspoke. 06 does relate to permanent partial, as well. I think the fact remains that where these issues have come up is in the permanent total disability area. That's why I believe OAH is considering now whether a claimant can request permanent partial disability benefits separate and apart from a scheduled award. And that's not the purpose, at least of the Atkins matter, because Atkins clearly is a permanent total disability matter. As we all will have to wait for OAH and the CRB to adjudicate the issue of whether a claimant is eligible for permanent partial disability wage loss benefits on a continuing basis, if she's eligible for a scheduled award. But again, as I said, that's not the case here. To address the burden of proof issue, DC law and the Administrative Procedure Act generally provide, as has been indicated, that the burden of proof is on the proponent of an order. However, ORM has sought to avoid meeting that burden by switching the burden of proof to the claimant. And I recognize that there is language in the Comprehensive Merit Personnel Act that accepts hearings from the provisions of the DC APA, but there is nonetheless a provision in 623.24B2, which provides that the hearing procedures that have to be followed are conducted in such manner as to best ascertain the rights of the claimant. And in that regard, best ascertaining the rights of the claimant, I believe, it provides that the burden of proof continue to remain on the Office of Risk Management, consistent with the DC APA, consistent with the federal process that from which under the Federal Employees Compensation Act, which was the model under which the DC program was provided. Under the DC Workers' Compensation Act, the same burden of proof rests with the proponent, and under the Police and Firefighters Board, under the Key case, which is a compatible case in terms of the benefits being provided. That provides that the burden of proof is consistent with the DC APA on the proponent of the
Your opponent argues, though, that all of that being true, there is language that was added that suggests a less stringent requirement for modification. The phrase "reason to believe," the mayor may modify if the mayor has reason to believe. Reason to believe doesn't sound like a very demanding threshold. And so what do you make of your opponent's argument that is a statutory basis that allows ORM to use its expertise to figure out where best to allocate the burden of proof in this context?
I don't believe that that's the process under which ORM can initiate a termination. If that was the standard under which the city council adopted for terminations, we would go no further than for them to produce evidence before OAH that they had reason to believe that grounds existed. That even risk management hasn't said that that's the case. The burden of proof under the law has always been to prove that one or more grounds exist for the termination of benefits, whether that falls to the claimant or that it didn't happen, or it falls to risk management that it did. I think that the burden of proof in these cases is far greater than having some theoretical reason to believe that the condition has changed. I think looking at the history of the CMPA and changes that have been made since its inception, between Section 44 that Council has pointed out and Section 2A, I think it's clear that the opportunity to fashion a burden of proof in this case falls with OAH rather than with ORM. In 44A initially, the CMPA afforded ORM the authority to place the burden of to impose all regulations dealing with the program. In 1979, when the CMPA came in to effect, Section 02A did not exist, and Section 44 provided that ORM had the authority to adopt rules and regulations for the conduct of hearings under Section 24. In 2001, however, the City Council carved out an exception to the mayor's authority under 44 by adopting 02A, which provides that the mayor shall administer and decide all questions under the act, except for disability compensation hearings and adjudication powers, which the City Council initially reserved to the director of the Department of Employment Services. Subsequently, in 2000,
are you arguing in effect that 623.02A kind of impliedly repeals 623.44.7, because 7 does seem to pretty directly authorize the mayor, and through a bunch of convoluted events has now become ORM for this purpose, to issue regulations that relate to the standard of review, including the standard applicable to a modification process or appeal under this chapter, which seems to be not just like the initial determination by the employing agency but also the layers of administrative review. So are you saying there's some sort of kind of implied repeal? I hadn't seen that in your brief, and so
I'm not saying that 02A repealed 44. Those sections of 44, in fact, came in 2004 as a result of a United States District Court case called Lightfoot. I think it's 339 Fed Sup, in which a class action was brought against the District of Columbia for failing to maintain due process standards under the CMPA for the termination of benefits. And the court initially ruled that the CMPA violated due process. As a result, the City Council adopted those provisions in 623.24D, which we've been talking about this morning. And at the same time, the City Council adopted 44 or extensively modified 44 to contain that laundry list of 7 provisions that attach to the due process determinations regarding the basis for termination. I believe the two have to be read consistently under the Nunnally case, and I believe they can be read consistently by referring where 44 refers to 24 and says that the rules that they adopt under 24, they can adopt rules under 24. Section 02A relates to rules for the adjudication, hearings and adjudications, and it relates to section 1-623.28. And I think that therein lies the continuing obligation of what was DOES and is now the Office of Administrative Hearings to adopt rules regarding the hearings process. And among that hearing process clearly is the adoption of the burden of proof. And ORM has in fact adopted a burden of proof rule and has always had it, that the burden of proof rests with the proponent of the rule or order.
You mean OAH? In your last sentence, you mean OAH?
OAH, excuse me. Yeah, OAH bears that burden. That since 2004, the City Council transferred the hearings authority from the director of DOES to OAH. It didn't actually take place until 2016, the transition, but the statute itself was changed in 2004.
How do you explain the language in subsection 7 of 44 then, which says the standard of review, including the standard applicable to the modification process or appeal? How did that's designated to ORM?
Yes, and I believe that goes back, relates back to 24, as the statute says, and it relates to the standards under which risk management decides how to proceed with the termination of benefits. But I believe to read the two consistently, I think unless you're going to read out the authority of the Office of Administrative Hearings, they also have that authority, and I believe they've exercised it as well, inconsistently with the authority exercised by the Office of Risk Management.
What is, in your view, what is the impact of the repeal of the ORM regulation on this case?
I believe it's just a restatement of the fact that OAH believes that its Rule 2822 and the Mahoney standard are the applicable standards to be provided.
Mr. Levy, can I take you back briefly to give you an opportunity to complete your answer to my earlier question of how you reconcile 623.07, which says that only after temporary benefits have been terminated or ceased is someone eligible for permanent benefits. How you reconcile that with 623.06A? In other words, how do we, don't Ms. Atkins' temporary benefits essentially have to be terminated to allow her to be eligible for the permanent benefits? And if not, how do we get around that?
Well, I think we get around that by the fact that there should not be a gap in benefits by virtue of a termination which could last for years during a litigation process. In order to be fair and comply with the humanitarian or remedial objectives of the CMPA, there has to be an orderly, seamless transition from permanent total disability benefits, temporary total disability benefits to permanent total disability benefits, where the claimant's disability is in fact permanent.
What in your view is that mechanism? Do you think that 623.06A provides that mechanism sufficiently, or are there other provisions that we may not be focusing on sufficiently here that allow for that seamless transition? I think you make a compelling point that there shouldn't be a gap in or loss of benefits while waiting to transition from one status to the other under the statute. But how do you see the statute providing for that?
I think the statute provides, as Your Honor has suggested, that within the last 52 weeks of the 500 weeks of receiving benefits, the claimant is obligated to request permanent total, and Ms. Atkins, in fact, did. I think risk management is accepting that fact because, at least to my knowledge at this point, it has not terminated anybody's benefits where they have applied for permanent total disability benefits outside and apart from the other terminations that they did with regard to Atkins, where they relied on a determination of MMI status, which I think is outside the scope of their authority to do. I think clearly there is no provision in the CMPA to terminate benefits for the sole reason that a claimant has reached MMI.
But I get your point, and it works well with respect to somebody who is permanently totally disabled, assuming there is that kind of relief available under these provisions, which I gather is disputed. But assuming they are, then who cares whether it's the same payment, and whether people figure that out sooner rather than later doesn't really matter. And the key thing is not to have a gap. I get that line of thought. But if in a different situation, imagine I am an injured employee and I get temporary disability for a week, and then I pick a terrible scenario. I'm in a coma, and my doctor says I'm never going to get better, and so the district says, okay, well, we need to go into total, or maybe that's not a good analogy because it won't matter. Let's say instead I have a 20% impairment to my leg. And, the district's view is this is now permanent. Imagine that like a week afterwards, the doctor says, this is never going to get better. We're at maximum medical improvement. And the district says, why are we going on these temporary benefits for someone whose condition is not temporary? There is a statutory scheme that permits for an award, which is scheduled awards, and assume that I would qualify. We need to shift over to that, and we shouldn't wait 10 years before we do that. And then instead of having it wait 10 years of temporary benefits and then shift over, we should get an accurate determination sooner rather than later. Is there a statutory mechanism in your view to address situations like that? Or is there just the district kind of has to pay temporary benefits even for permanent conditions for 10 years?
As I said, Your Honor, I think there's an issue as to whether, to use your specific example, whether a claimant can request permanent partial disability benefit, wage loss benefits on an ongoing basis if the person is eligible for a scheduled award. So that issue is being adjudicated not by me but by others, at least at this point, to my understanding. So I'm not sure that that's a fair example to use. But
I guess my question is, you don't. If part of figuring out whether what ORM proposes to do here is reasonable is figuring out what its implications are. And if one possible implication of your view is what I was just describing, which is somebody who has an injury and gets some temporary wage loss benefits and wants to, and the district wants to say after a few weeks, there's no point in doing anything temporarily anymore because this is maximum medical improvement. There shouldn't be temporary benefits anymore. We need to shift over to permanent benefits. And let's say in a case that's undisputed, there's a scheduled award that would be available. If the consequence of accepting your view is that the district has no remedy there, then that that bears on the reasonableness of ORM's contrary view. Whereas on the other hand, if no, the statute actually has a way of reasonably addressing cases like that other than what ORM proposes, then that's a different matter. And am I right to say you're not sure what the other approach would be, but that's a matter under litigation? Is that a fair summary of what you're saying?
In a situation, to use the Atkins example, if I can, if ORM had not gone in the direction that it went in Atkins and determined that she was at MMI, if they had determined that 25 years ago, there should have been an opportunity for her, because she doesn't even have a scheduled award under 07 for which she's eligible, she certainly should have had the right at that point to transition immediately into permanent total disability benefits. There's no statutory provision that, because she would not have been at the 500 weeks. And I don't believe that there's any regulatory provision for that to occur. And that's why so many of these people have just stayed under temporary total disability benefits for as long as they've been injured, which in many cases is far longer than 500 weeks. They are now going into that process of where they have to establish that they're permanently totally disabled, but that's only as the result of 06A coming on board after 2010 when it was first adopted.
All right. Thank you, Mr. Levy. Unless you have anything further, we'll wrap up with the rebuttal argument from the.
No, we just simply ask that the Court of Appeals affirm the decision and order of the Compensation Review Board in this matter.
All right, thank you. Ms. Pittman, we'll give you a couple minutes for rebuttal.
Sure, I'm going to be as quickly as I can, because I know that you've been very generous with time. We have a couple of clarifying things, though. I want to start with the presumption that there is nothing in the schedule to address Atkins injuries. I think that that's premature, but it's also probably inaccurate. A spinal injury, a lower spinal injury, frequently will have loss of use of legs, which is the schedule that would fall under. And in a spinal injury more associated with the neck will frequently have loss of use of shoulder and arm, and that's the schedule that it would go under. And so I think it's inaccurate to state that there is no available schedule benefit for Ms. Atkins if she goes down that road. I also want to clarify that individuals who reach maximum medical improvement doesn't mean medical benefits are terminated. They were terminated here on a causation issue. People who are on permanent disability schedule awards can continue to get medical benefits if there's still a causal connection. So I don't want anyone to think that MMI equals loss of medical benefits. There was a couple of other things that came up, whether or not the CMPA has non-schedule awards. It does not. There is a provision specifically in the Private Sector Act. There is not one in the Public Sector Act. I
know that's ORM and the district's position. Is that something that has been determined by this court or by the CRB?
I don't know.
Is it reflected in clearly reflected in ORM regulations somewhere, like explicitly in some ORM regulation?
So I believe the regulations do indicate that permanent awards are based upon the schedule only. And I don't think that this court has had a published decision. There is an unpublished decision that I worked on in which someone was trying to seek an award, a permanent award that was not on the schedule, and that was denied. And this court.
There's a published opinion which I was on where someone, the name of it's not looking immediately to mind, where someone was claiming, I think like PTSD or other ways of describing it. It wasn't on the schedule. And the court published an opinion saying you can't have a scheduled award under the schedule statute, but not meet any of the scheduled subparts. But that opinion left open the question of whether there are total, unscheduled permanent awards. That's, can't remember the name right now. I can find it, but in any event, so there's at least that. But I just want to make sure you agree with your opponent that that's the position that ORM and the district have been taking, but that hasn't yet been determined, as far as you know, by the CRB. I'll have to go back and look at the regs. I didn't remember seeing anything that was used a word like only about scheduled awards being the only permanent relief. It is right that there isn't an explicit reg about unscheduled permanent disability. So in that sense, maybe there's an implication, but sorry, I just wanted to make sure I understood the support for the assertion you were making.
Sure, and I actually think we were thinking about the same case. I had not realized that Sheila Jordan was published. That's my mistake. Sorry.
That's right, Jordan is in. Thank you.
As soon as I realized we were on the same page. Okay, so The repeal of a permanent total disability, 0.07B was repealed. And I would just like to note, I don't want to get into a long discussion on that because that's not really right for this case. But there is currently pending before the council. The executive has offered legislation to restore permanent total disability and to also address the fact that the schedule does not have all impairments on it. And so that's pending. There hasn't been a lot of action on it, but I will say that is something that the ORM does view that their hands are tied with the CMPA currently as written. The final thing I want to talk about is on burdens. So council's argument about 0.02A and 0.44, I think it's important to note something here. 0.44 was amended in 2010. So this was after 0.02A already existed. And the amendment added to it that ORM shall promulgate rules for the conduct of hearings under section 1-623.24, right? So that is an explicit acknowledgement that it is ORM's rulemaking authority. The court has already pointed out subsection 7, which goes directly to the standard of review, which I think is also applicable. And I would also like to point out that OAH does not have rulemaking authority under the CMPA. And that's actually consistent with this court's decision in East Capital Exxon, which is that OAH is a generalist body. It does not have subject matter expertise. And so it would not make sense for them to have rulemaking authority under the workers' compensation provisions. The rulemaking authority, as this court has recognized in both Webb and Frazier, is with ORM. And just to cap that off, 0.02A does not provide rulemaking authority to the CRB either. The rulemaking authority is in 0.44. I know I'm way over time. I apologize. Thank you so much for indulging me this morning.
All right, thank you. I'd like to thank both counsel for your briefs and arguments today. And that concludes our argument in this case. And you are free once our clerk of the court adjourns us to exit our virtual courtroom.
This court will take a short recess. This court is back in session. Please come to order.
Thank you, counsel. We'll see if we got that worked out. I appreciate everybody's patience as we try to do this all remotely.
How's that? Is it better? I'm trying to move closer to the mic.
Yeah, it might help. I don't know if your volume is as high as it could be, but turning the volume up might help a little as well.
How's that? Is that better?
Somewhat.
Yeah, I think to piggyback on Judge Buclise's comment, the cutting out seems to have resolved itself, but now the volume seems quite low. So we will listen closely, but it might be helpful just to
Louder.
stay close to the microphone and speak at a slightly uncomfortable volume.
Okay, we'll do. All right, good morning, Your Honors. May it please the court. Roddy Dennis on behalf of the appellant, Michonne Bill. I'd like to reserve 3 minutes for rebuttal. In this case, the trial court committed a few reversible errors, some of which are addressed in Bell v. First Investors, and 3 of which are as follows. First, by failing to follow the court's precedent when it comes, for failing to follow the court's precedent relating to a full and fair opportunity to litigate. In the FISC small claims suit, defendants would be considered third-party defendants. Rule 14 governs when a defending party, like Ms. Bell is in the FISC small claims suit, may bring in a third non-party like the law firms. Specifically, only when a non-party is or may be liable to the defendant for all or part of the plaintiff's claim against the defendant can the defendant become a third-party plaintiff in the same suit and bring in a non-party. As such, the plain language of Rule 14 prevents Ms. Bell from naming the law firms as third-party defendants in the FISC small claims action because the law firms cannot be held liable for any part of Ms. Bell's debt to FISC. Second, By failing to apply the court's precedent relating to res judicata and privity, and instead applying what is termed as bogus privity, finding that the law firms are in privity per se without explanation. For example, defendants argue that they are the agent of FISC. However, the court has defined when an agency relationship exists, and that is where the principal has the right to control the agent's manner or method of achieving desired results, and doing so. Defendants have not established such a relationship or its scope. Third, by failing to put the law firms to their burden of arguing and proving all the elements of the asserted res judicata defense. It is defendants' burden to argue and prove the defense as a matter of law. Defendants failed to meet that burden, and the court had an inadequate basis to render its decision. I would also like to address defendants' offer up of lengthy arguments on issues that defendants did not make or mention in their opposition below.
Ms. Dennis, can we just start with, because, you know, nobody flagged via 28K letter this court's opinion from August in Bell versus Fisk. You're both obviously familiar with it. What, in your view, is the effect of that opinion on the dispute between the parties now?
Well, the court found that there are the defendants were compulsory counterclaims are not allowed in small claims court. So the defendant Miss Bell was not required to bring her claims against FISC.
Right, that they were not compulsory. Okay, and then what?
That's the main claim, and also with respect to they were permissive counterclaims. They also said that because Ms. Bell did not waive her rights under the settlement agreement, because the plain language of the settlement agreement does not actually does not waive Ms. Bell's rights against the actual creditor, FISC.
Let me see if I can get to the meat of it a little bit. So I think you're right that it says these counterclaims were not compulsory but permissive, but nonetheless, res judicata would apply where allowing them to proceed would nullify the prior judgment that was settled. And the court then kind of looked at each of the claims. I think at least one it said was totally precluded, the abusive process claim between those parties. Some it said aspects of the AFRA and CPPA claim are precluded, namely those aspects that attack the amounts due, but other aspects of those claims are not precluded. And I wonder if you think now, you know, we kind of take that opinion and we take its analysis and just apply it here, or not. And if not, well, why not?
I don't think it applies here because, for one thing, defendants were a third party, and FISC was a plaintiff, so that involves a counterclaim. This involves Rule 14, where Ms. Bell could not name the defendants. Defendants were not a party to the suit.
Ms. Dennis, can I ask you a question about your Rule 14 response? And you started with Rule 14 too, and I remember references to Rule 14 in your briefs that where I thought you were making a different point. So I want to make sure I'm following along. You were definitely relying on Rule 14 as support for your argument that counterclaims like this were permissive. But I take your argument today to be, it's more than that. Actually, if you look at Rule 14, it would not have been possible for your client to have named the law firm in the small claims action.
Yes.
And was that argument made? Has that been made previously? Was that made in your brief in this court? Because I'm not sure I caught that.
Yes, I did make the argument in my brief. I believe I have it on page 10 in my opposition below. On page 10 of the opposition below. Also,
I'm asking my question. I hadn't yet focused on whether it was made in the trial court, but just could you help me with whether it's made in your briefs in this court?
Sure. Page 25 of the opening brief and page 8 of the reply brief.
Thank you. I'll take a look at those. I may have missed something.
Okay. As I said, I was speaking about the opposition brief, basically making brand new arguments that were never made in the opposition brief never made to the trial court below.
Can I ask you, I sorry to interrupt because I did check, and when I'm looking at page 25 of the opening brief, I do see an argument made about no full and fair opportunity, but I don't really see anything about Rule 14 would have precluded, Small Claims Court Rule 14 would have precluded you from adding the firm. Now, maybe that's in your reply brief or maybe it's elsewhere, but I just, you mentioned a page in your reply brief. What was the page in the reply brief?
I believe she said page 8, although I only see reference to it on page 7 in a footnote. I mean, I'm jumping in because I had the same question. The Rule 14 argument sounds like one that I hadn't thought of, and maybe I missed it, but I don't recall it being made.
I will try and find it in my brief, but I actually stated that I would, that she could not bring her claims below.
I mean, so press that in rebuttal. I don't mean to derail you from the point you were trying to make. I just was a little bit thrown because you were making this argument about Rule 14 that wasn't ringing a bell, and I just wanted to make sure I got oriented on it. But I understand, I think the gist of the argument, which is if we look at the text of Rule 14, it's not just that it is permissive, it's that Rule 14 actually would have made it impossible for your client to have included the law firm as a I don't know, third party defendant in the small claims matter. So I think I understand the gist of the argument. I just have some uncertainty about whether it was presented in the briefs in this court, and you can focus on that in rebuttal if you'd like.
Sure. And I did argue. I said that she could not bring her claims under specific. I believe I specifically said that she could not bring her claims under based on Rule 14 in the small claims matter.
Well, sorry, it certainly says she could not bring compulsory counterclaims. I guess I just didn't know that was a Rule 14 argument that you were making, and it's not clear to me from looking at that page 8 of your brief that that's what the argument was. But that's okay. We could point. I understand the position generally being that she was not even entitled to bring in the law firm. Do you want to just articulate for me why you think that is? Well, why she could not have brought her claims, counterclaimed against the law firm? Why that's not allowed?
I'm sorry, Your Honor. If I could just, I will. I'm sorry. Why he could not bring.
So I mean, I understand one argument. So one argument that I definitely understand you're making in your briefs is, in terms of permissive counterclaims, those shouldn't have res judicata effect. You didn't have to bring them. But that's, that runs into the nullification issue that we addressed in the prior opinion. So now you're saying, well, she couldn't have even brought these claims. She couldn't have even counterclaimed against this non-party law firm because they weren't in the case. And I wonder if you want to walk me through what you think, what in that rule precluded her from doing that.
Well, the wording of the plain language of the rule, which says that she can only name a third-party defendant if they're liable for any part of the debt that she owes to FISC. And I actually said in my reply brief on page 8, and Ms. Bell, Ms. Bell could not bring third-party claims against the defendant. Sorry, against the law firm. That's why I said that Ms. Bell could not bring third-party claims, as opposed to saying that they were permissive. But with respect to, I also would like to address, as I said before, the multiple arguments that were raised by the defendants in this case, which I believe do not have merit. But as I said before, unless the court wants to sort of disregard much of the Supreme Court and this court's preclusion precedents.
I'm sorry, Ms. Dennis, can we just talk about 14A3 for a second? Because I understand your plain language argument as it applies to A2. A3 says the plaintiff may assert against the third party defendant any claim arising out of the transaction or occurrence that is the subject matter of the plaintiff's claim against the third-party plaintiff. Now, I take it you think that that is sort of modified by that. That's only if they were allowed to bring in the third-party defendant in the first place. It was only if they could bring in the third-party defendant as being on the hook for part of the claim against them, and that kind of modifies.
Correct.
That's okay.
But with respect to, as I said, just going back to the opportunity to actually litigate her claims against the law firms. As I said before, Ms. Payne and Ms. Bell was actually, as I said, prevented by Rule 14. In addition to the fact that she was unaware of any claims that she may have against the law firm because that was concealed from her at the time. She signed the settlement agreement on the first day at the first hearing. And she didn't even fully complete the hearing. So she was unable to bring it there. She was not unable to assert any claims against the law firms because, as I said, she had no knowledge of those. She also had no right to appeal in small claims court because, as I said, with respect to the defendants are not parties to the actual claim. And she couldn't appeal. She was denied her appeal to appeal the FIC judgment, FISC judgment. The thing is that with respect, under no circumstances would the law firms be, as I said, liable for the debt. And Ms. Bell also lacked an opportunity to litigate because she didn't choose the occasion, her adversary, or the small claims forum of the FISC, made all those choices. And specifically with respect to
So, Ms. Dennis, just I want to, at least direct your attention to what troubles me a little bit. So I think the argument goes that they were just an agent and in privity with FISC. And so whatever claims you could have brought against FISC would, also be barred against them in sort of a under analysis of privity. That you could have brought it against their client before, and that would have bound them in the same respect. And so there's a privity analysis that I'm not hearing. So we have certainly said, in Smith, that parties can be in privity and res judicata effect can extend to unnamed parties in the prior act, in the prior action. So that's very clear, I think.
If they're correct, and if there is a pre-existing substantive relationship, you said that in Ed Care Management Inc. v. DeLucy, and that's what came out of also came out of Franco. Defendants are not, and also with respect to the principal agent, if you're trying to establish, if you look at each of the actual types of privity and you look and go through the elements of each, they don't meet that type of privity, especially with respect to principal agent. Principal agent requires that the claim in both the first action and the second action be exactly the same. Well, this one is involving a completely different party. So defendants do not.
I don't think that can quite be right. The doctrine that sometimes an agent and a principal are in privity for res judicata purposes necessarily is implying that in the second action, someone new who wasn't in the first action, either the agent or the principal, is going to be bound or is going to be able to take advantage of, depending on what kind of, who's precluding what about whom, a determination in the first action. So it can't be that doctrine applies only when the parties are exactly the same, which is what I thought you were saying. There is language whether their interests are the same, and that I get. But
correct. And that's the main point. I say with respect to the agent and principal, that not. And I'm sorry if I misspoke, but what I meant to say is that the interest of both the subject matter of the actual suit, their rights with respect to the subject matter of the specific suit must be identical. So with respect to the breach of contract, claim, and this is a consumer protection violations against the law firm, they're not identical. And redevelopment says that the interest has to be identical. They must be so identified in interest that with respect to the subject matter of the first suit, that is why they would be able to take advantage of preclusion. Here, this is not, defendants are in no way have no financial or proprietary interests in the subject matter of the first suit. They have no rights with respect to that. They were simply an intermediary litigating on behalf of their client. They were an attorney litigating on behalf of their client. So with respect to the court's jurisprudence with respect to establishing whether or not identical interests are there, they have not met that burden because
there's some other possible grounds for privity, including control of the litigation. And I ask about that because we do really the only case of ours that talks about privity and attorneys and their client and attorneys who are non-party attorneys, I guess you could say, is Smith versus Jenkins, where we did find that there was privity. And part of our discussion is about the fact that the person claiming, the non-party claiming privity subsequently was an attorney in the first action. That was the judgment that was being relied upon as the source of preclusion, and thereby had some ability to control what went on in the first litigation. And so I wonder if you want to address why you think there isn't privity here on a kind of attorney control theory.
Sure. Well, the Supreme Court has addressed that. They addressed it in Taylor v. Sturgill and also in South Central v. Alabama, I believe it is, where they're both the plaintiff in both suits shared the same attorney. That was identified in both of those suits. In Taylor v. Sturgill, the attorney for the plaintiff in the first suit was also the same attorney for the plaintiff in the second suit. The same thing with respect to South Central Bell. The same exact thing. And the Supreme Court actually rejected that theory that the attorney somehow the client's judgment actually travels with the attorney, because the attorney has no financial or proprietary interest in the subject matter of that suit. They are simply an intermediary who's litigating the suit. They're not actually, they have no proprietary interest in it. As I said before, so that theory has been rejected by the Supreme Court on a couple of different occasions with respect to just having a sort of per se privity based on the attorney-client relationship. As I said, in both of those cases. Also, with respect to the assumed control element of privity, that particular exception, you have that actually in Montana v. United States, basically they said, the Supreme Court said that only collateral estoppel applies to those types of cases. So there has to be actual litigation. Basically, it says preclusion of non-parties falls under the rubric of collateral estoppel rather than res judicata, because the latter doctrine presupposes identity between causes of action. So even if defendants have not argued collateral estoppel, they've only argued res judicata, and it doesn't actually, it's not applicable to that particular exception. As I was saying, with respect to I'm sorry, I wanted to actually address, I believe it was in redevelopment where they said that the interests of the parties have to be identical. And this court has also, through the majority of its jurisprudence, says that the party must be so identified in interests with the actual initial litigant that would be the only situation would actually justify preclusion in that situation, in that sense. And if we can lay out what defendants are actually trying to do here, it's basically asking the court to find privity. The law this is basically an extreme form of privity that was complained by previous courts or previous Supreme Court decisions. But the law firms are requesting that the court immunize it for litigation misconduct, which is litigation misconduct is a violation of district law. If you used to make if an attorney debt collector makes a false statement in court, that is actually a violation of district law. DCL, I believe it's F5. You can't make false statements regardless. And once you make the false statement, that's a violation.
Is that one of your claims?
I do bring unconscionable, I believe it is under DCL. Under my DCL claims, I believe I specifically reference F, 393814F. And basically, as I said,
Council, I see that you are over time. If my colleagues have questions, I'm happy to have that happen. Otherwise, why don't you try to wrap up in a couple sentences, and then we'll give you your 3 minutes in rebuttal.
okay, as I said, with respect to Hines and the FDCPA, the DCL all makes defendants conduct a violation of the law. So to immunize them based on a mere attorney-client relationship, by saying that they have privity based merely on an attorney-client relationship, basically immunizing them for litigation misconduct that is found a violation of Hines v. Jenkins in the Supreme Court said that litigation violations, lawyers can commit violations of the FDCPA during a litigation, the FDCPA and the DCL and the CPPA.
Thank you, counsel. As I said, we'll give you 3 minutes of rebuttal. We'll hear now from Mr. Ross.
Good morning, Your Honors. David Ross on behalf of the appellee, Weinstock, Friedman, and Friedman, now known as Friedman, Fram, and Thrush. One is the law firm predecessor. The other by merger is a successor law firm. So it's the same law firm. So for ease of reference, I'll just refer to it as the law firm for brevity purposes. There's only one issue that's still ripe for this appeal, and that is something that Your Honor is all focused upon. That, of course, is the issue of whether the law firm was in privity with its client, First Investors. We all know why, because this court, in its decision in Bell versus First Investors, which is published at 256 Atlantic 3rd, 246, disposed of all claims that were asserted by Ms. Bell against First Investors after the time of the repossession of her vehicle. Ms. Bell has not raised any argument that the law firm was involved or even retained at the time of the repossession of her vehicle. This court made it very clear that all allegations, all claims leading up to and included in the filing of the Superior Court action against Ms. Bell are precluded.
I'm not sure exactly what that means, but let's just walk through them real quick.
Certainly.
In her complaint, there is a AFRA claim. I think we previously said part of that survived a res judicata analysis as against Fisk. I think we said the same thing as the CPPA claim and the DCL claim, but not as to the abuse of process claim. So is your view that same analysis from August applies as to your client?
Well, here's why it would, as long as privity applies to the law firm. The complaints are virtually identical. They're almost word for word complaints. The same allegations and accusations are raised in both complaints against both First Investors and the law firm. The only difference would be one, the repossession related allegation against First Investors, and then two, the complaint against First Investors also contained a defamation cause of action. Otherwise, the causes of action are essentially identical.
You're assuming that if there's privity, which again is obviously what you were describing as the central issue in this appeal, maybe the only issue in your view, but you seem to be assuming that the nullification / impairment analysis would carry over, even though your client, even assuming privity, you seem to be assuming that privity would also mean kind of that you would carry over your client, the analysis as though your law firm was Fisk for purposes of the impairment and nullification analysis. And it seems to me that's not obviously so. If you look at some of the formulations of the impairment, the nullification impairment analysis, it refers to nullifying or impairing rights under the judgment. And if your client doesn't actually have any rights under the judgment, Now you could think, I mean, maybe privity just carries over into this analysis too, but it's not obvious that it does. And so let's assume for a moment it doesn't necessarily. What rights did your client have under the settlement in the original judgment by settlement?
Well, if you think about the rights would be not to have Ms. Bell bring allegations against the law firm leading up to and
why would the settlement create that? I mean, nothing in the terms of the settlement creates that right. So what do you think creates that right?
The resulting judgment and the lack of any raising of these allegations at the time the judgment was entered up to that point in time. So because all of the allegations, of course, lead up to the
That's
judgment.
Very circular to me. If the mode of analysis from Bell 1, if I can call it that, the earlier decision in this case, in the related case, if the mode of analysis is generally Ms. Bell was not required to bring any of these claims in small claims court because they were not compulsory. And so really there's generally not going to be any res judicata, and that action is really only going to determine what it determined. But there's an exception, and what you can't do is you can't, what Ms. Bell can't do is to present claims that would nullify the rights created under the first judgment. And so then you look at like what were the rights created, and they weren't. Well, the right that was created was a broad, res judicata right not to have any further litigation. Otherwise, all of the claims would have been barred. And so the analysis has to run beyond res judicata, which would apply if there was a requirement to have brought the claims. We basically were saying generally res judicata did not preclude Ms. Bell's claims, and there had to be a special showing that permitting the claims to go forward would nullify or impair rights under the judgment. And so I guess if your only argument is the judgment created res judicata rights that would be impaired, that seems circular to me. Is there any other right other than what the kind of claimed res judicata rights that you're claiming through privity? Was there any other right that it created in the law firm, that earlier judgment created in the law firm?
Well, first, I disagree that you can necessarily parse out the allegations that are being raised against the law firm here, the mirror allegations that are being raised against First Investors. It's all baked into the same analysis, and it's all baked into
out. I guess what I'm trying to figure out is if we say in Bell 1, generally no res judicata, but we're not going to let Ms. Bell kind of come back in and take back the money that she got, from the clients who got the client, Fisk, who got a judgment against her. We're not going to let her have claims that are going to come back in and take the money that there was a determination that Ms. Dennis's client owed the Fisk. If that's our analysis, then it's just very unclear to me whether permitting the claims to go forward against the law firms are going to, have that form of like taking away a right that, the judgment created for Fisk to have some money. Permitting Ms. Bell's claims to go forward and get that money back, we said, for certain of the claims would be a nullification or impairment of the rights that Fisk had under the judgment. And so I'm just trying to figure out what rights your client, I'm not trying to parse one claim or another so much as trying to figure out, are there, what rights, if any, were established in favor of your client by the judgment. And so far, all I hear is what seems to be a somewhat circular argument about, well, we had a res judicata right that arose.
Here's what this court said in August with regard to First Investors. The reason why Ms. Bell's claims are precluded is because they challenge First Investors' right to the sum awarded to it in the 2018 judgment. Ms. Bell's allegations against the law firm here directly challenge First Investors' right to the sum awarded to it. She already said it was a fraudulent affidavit.
That's what you mean. Some of them are logically inconsistent with the idea that Fisk should have won that action. But unlike in Bell 1, Ms. Bell is not trying to actually take that money back from Fisk. So, we've already said we're not going to let her take that money back from Fisk. And the question is, how does it impair the judgment to allow her to get whatever relief she may be otherwise entitled to against the law firm? And if Fisk gets to keep its money, it's not clear to me that the impairment that you're, this kind of abstract logical inconsistency is the kind of impairment that is required. It's not clear it's not either. I mean, I think our opinion, Bell, is a little murky on that, but this is not trying to parse out the claims. This is a question about whether the difference in your client's status, having no actual legal rights, directly reflected in the judgment, like person X gets X amount of money. It may be that there is no interest that your client has that would be impaired by allowing or nullified by allowing Ms. Bell to go forward on all the claims. And that's really about what rights your firm had in the judgment, and also what impairment and nullify mean.
But we'll keep in mind that this court wisely stated in its August decision that the doctrine of res judicata, I'm quoting on page 256, note 11, operates to preclude assertion of all rights of one party to remedies against the other party with respect to all or any part of the transaction or a series of connected transactions out of which the action arose.
Yeah, that's kind of interesting. I'm not to piggyback on a question Judge McLeese had. It kind of depends on what you mean by asserting claims. Like in one sense, it is true. I take it that we've said clearly she can't claw back any of that money against Fisk, and that's the basis of our judgment in August. But if you read it in a broader sense to mean she can't undercut some factual predicate of that judgment, well, that doesn't sound like res judicata at all to me. That sounds like issue preclusion. And the general rule, in fact, I think an ironclad rule, if I'm not mistaken, is that settlements don't have issue preclusive effect. They can only have res judicata effect. And so I tend to think when we said that in August, we meant it in the narrower sense that she couldn't claw back money from Fisk, not in the broader sense that she can't attack a factual predicate as against a different party, because that to me sounds like issue preclusion, which is not raised here. And it doesn't look like we meant to comment on that in our last opinion either. I mean, do you think that, does that to you? I mean, that sounds like issue preclusion to me. What about you?
Well, to me, keep in mind you're parsing out the fact that there was also a judgment entered here. It'd be different if it was just a settlement agreement. It's also a resulting judgment that's entered against Ms. Bell in the underlying court. Secondly, you have to ignore
a judgment based on we do not know the factual predicates to it, though. I mean, for all we know, if this judgment were entered for $0, it would still have res judicata effect, right? If your client had brought, if Fisk had brought this suit against Ms. Bell, and then immediately showed up and said, you know what, this is a bogus suit. We dismiss it without prejudice. Here, sign this, and $0. We're in the wrong. That would still have claim preclusive effect. The same claim preclusive effect, I think, as this judgment. Do you disagree with that?
I think you're ignoring the fact that these are mirror lawsuits against First Investors and this law firm. The same accusations, the same allegations are being brought against both.
I don't mean to ignore that. Sorry, go ahead.
No, I apologize. How does that solve your problem? For example, people get to decide how to comprise their litigation, like in tort. You can choose to sue different people in different litigations, and so that's essentially what's happening here. They could have identical complaints, but unless they're like mandatorily to include them together for some reason, by default, you have choices as a plaintiff, right?
Essentially, then this court should just adopt a standard by which a party that does not obtain a favorable result in an underlying litigation has carte blanche to sue the prevailing party's attorney in another lawsuit and simply just recast allegations as they see fit. And that's not the standard. This court.
They're not suing the party because they're not suing the party because of anything, the result of the lawsuit. In fact, they sued the law firm at nearly the same time, right? It's because they have separate claims against them that they want to assert.
The claims are not separate. The claims are the exact same claims with the exact same verbiage, the exact same wording. You can literally copy and cut and paste the name of First Investors and the name of the law firm. There are no separate allegations here. In fact, the allegations and the causes of action against First Investors are broader than they are brought against the law firm. Once again, if you have different factual contours or constructs, then perhaps you'd have some valid basis to proceed. But this exact issue.
I get your point that, especially as a lawyer, it may be unsettling that after you represent a party, you might get sued for what you did. And there are a bunch of doctrines that limit the ability of folks to sue law firms and lawyers who are representing folks. But this question that we're addressing doesn't really have anything to do with that very directly, because the question that you're presenting is not some kind of law firm immunity generally, but just a question of whether this if it was going to be done, it had to all be done at once in small claims court. So it's really just a question of, whether actions like this are a good idea or a bad idea has nothing to do with how we resolve this case. Our case is, if there are going to be actions like this, they all have to get geared up immediately in small claims court. And in that respect, I just want to make sure I understand how practically the way you think this should have worked is that when FISC, again, assuming, I know you don't think there's any validity to the underlying claims, but imagine just procedurally how it should have worked. FISC sues Ms. Bell in small claims court. In connection with that litigation at some point, in Ms. Bell's view, or maybe also in front of that, even pre-suit, I don't know, it could be either in theory. But in some of the things that are filed in court, Ms. Bell's view is the law firm is committing acts that subject the law firm to suit, that are related to the representation and maybe to the underlying circumstances of the suit that was initiated by the law firm's client in small claims court. Your view is that the client the defendant in that setting is required, on pain of losing any ability to sue the law firm for, let's assume for a moment, was unlawful conduct that should be compensated substantively, is required in small claims court to file counterclaims against the law firm, which I assume will disqualify the law firm. I don't think it's very likely the law firm is going to keep representing, and then it's going to spin out into some litigation that seems extremely non-small claims courtish. It doesn't necessarily seem like that's a very practical theory. Now, maybe the law requires us to accept that view, but just in terms of what makes practical sense, it doesn't seem that appealing practically. Do you think that, but your view is procedurally, what Ms. Bell, if she had valid claims against the law firm, what she was required to do was to raise them in small claims court as third-party counterclaims, and then let that all spin out as it would into what would be probably a significant litigation involving different attorneys and multiple clients. Is that the gist of your argument?
Because of the unique context and the contours of the allegations raised here, which are mere allegations against both first investors and the law firm, then yes, the effort should have been made down below. But keep in mind, this isn't the first time courts have had to wrestle with this type of issue, where you have a debtor who's sued in superior court and then wants to go ahead and sue both the claimant or the creditor and the creditor's law firm. Quick v. Educap, a case that's certainly cited in the papers and relied upon by Judge Williams, addressed this very issue and said, no, res judicata applies because in essence, you're bringing the exact same causes of action. And of course, it directly implicates the underlying judgment, regardless of whether you raised it below or not. That's the purpose of res judicata.
I'm sorry, I just missed the case that you were citing. What case were you citing there? I couldn't quite hear it.
The Educap, it's relied upon by both Judge Williams, and it's also cited in the papers. The citation to that would be 318 F sub 3D 121. It was a federal district decision in 2018.
And remind me, is that a privity case, or is
No,
that a
that
notification
case did not address privity at all. So how that would be the distinction there, right? I mean, then there was no distinction in that reasoning between the client and the lawyer. And I'm concerned about your view of privity between the client and the lawyer also. I mean, is there any limiting principle that you would apply?
Well, of course, to the extent that the allegations deviated, or under your analysis, if somehow these were separate claims and distinct claims, which they're not, then that might have some validity there. Otherwise, we're saying, well, you have this carte blanche exception to privity, even though there's clear agency principles that have been repeatedly endorsed by district courts that say that attorneys act as agents for their clients. Otherwise, you're saying, well, then attorneys are just going to be exposed to any litigant that has an unfavorable outcome, and they can turn around and sue the attorneys and come up with whatever creative theories they can come up with in a separate litigation.
But again, just to be clear, the concern that defendants can sue or that parties can sue the lawyers for opposing parties. That's not going to be, this case isn't about whatever substantive limits there are on that. The question is just whether if the party wants to do that, it needs to do it in the same litigation. And then it'll spin out into some big complication there, or whether at least some of the time the party can wait and say, I have an action against the client, or I have an action against an opposing party, and that has its own set of claims. I think the lawyer is doing a bunch of terrible related things here, but I'm not going to bring that into this action. I'm just going to litigate this action, and then sufficient unto some later day, any lawsuit I have to bring against the lawyer. But this case isn't really about, is it a good idea or a bad idea, or is it a concern or not a concern to have litigants free to sue their opponent's lawyers? Because this is all just a question about when you have to do it. Or am I missing something?
I think that the danger this court might be walking into is indeed creating an exception to established and settled principles of privity, and particularly in a case where you have mirror allegations being brought against a client and its attorney. You're saying, well, the client, that's
You
fine.
say established and settled, but I mean, we have one case about kind of attorney privity that involved an attorney who was, had a financial interest in the first litigation. So we don't really have a case, this court doesn't, about a kind of a per se rule of attorney privity. And around the country, it seems like there's a pretty substantial division of authority. Some courts have a per se rule. Some courts say that per se rule doesn't make much sense. So I guess I'm not quite with you when you when you say that you're relying on sort of kind of an established principle that we don't really need to kind of think through and decide independently whether we should or shouldn't adopt it.
Well, certainly an established principle as far as agency. And then we haven't even, of course, broached the Smith v. Jenkins control principle, which would, of course, also apply with equal force here, even though you could say it's archaic, but it's been cited dozens of times by this court, never overruled, never called it a question. It's still good law to this day. So in essence, if this panel wants to overrule Smith v. Jenkins, then I guess that will be the court's has to take.
Actually, it's very different for a few different reasons. But let me touch on one. Can you point me to a case where the control principle of privity has been invoked by, been used against the defendant from the prior case? I mean, it makes sense to me that a plaintiff who controls the initial action might be on the hook for their choices and who they decided to bring into court. It doesn't make a lot of sense to me why. Well, first, I'm not sure on the factual predicate that your client controlled the prior litigation as opposed to your client. We could talk about that. But I also don't know why, if you did in fact control the prior litigation, why that matters to what Ms. Bell needed to counterclaim with. I mean, I get it if you were to then try to sue Ms. Bell, that makes perfect sense. That's what the facts look like on Smith. That's what the facts look like in every one of these cases, from what I can tell. It's where somebody who controlled the initial litigation brought an action, won or lost, and then re-brought it sort of in a different incantation, the lawyer maybe. I don't understand it being used. I guess maybe you could just explain to me why you think it would apply, why it would make any difference if you controlled the prior litigation, why that relates to Ms. Bell's rights to sue you when you were party to that litigation.
To the extent, under the unique circumstances here, where you have the exact same allegations, literally to the stray grammatical marks on your complaints that are being raised against the client and the attorney, then you would have a situation where you could say, okay, this is where it would apply. In most cases, it would not, because you have some varying or differing allegations, but you don't here. You have the same allegations being raised.
You're confusing the allegations in the complaint for Bell 1 and the allegations in this complaint versus what was actually at issue in the case where your clients represented Fisk, right? Those allegations were different. And that's what we're comparing. If that was can I collect this debt? And yes, they could collect the debt. The law firm didn't have the same interests in that at all. And that's what you need to compare.
The allegations and both the cases that are currently at issue here and the one addressed in August were that what you did that wasn't proper in order to collect that debt down below. That's why you can't, again, as I said before, you can't really parse out the two that neatly. That's why this court in August said the only thing that survives is going to be the actual repossession itself. That's it. And there's no allegation in the law from any involvement with that.
Okay, I'm quoting from Smith here. It says, thus, to the extent Hughes undertook in Maryland to represent interests substantially the same as his own, his participation in the current matter as a party must be barred by claim preclusion, right? It had to have substantially the same interests in the underlying action that he controlled. What were the law firm's interests in the original litigation for the debt?
Right, and there's going to be that of course is a different factual construct. Obviously, the interests are of course representing your client. That's why the agency principle applies clearly in privity. That's why repeatedly we find, and the courts find, that attorneys are agents for their clients, the principals, and in the context of a litigation that you handle as an attorney representing your client, that's a clear example of agency, and therefore privity applies.
Just to make clear, if you think this works symmetrically, so imagine instead that Ms. Bell had won the small claims action, and the small claims judge had written that the $785 demanded was in violation of the law. And then imagine that your belief would be that would be race judicata. You're in privity, and so that determination, if some other third party wants to come in and for claim preclusion or issue preclusion, depending on the circumstances, somebody else would come in and say, well, it's true that the law firm was just a law firm, and there's a judgment against his client that says something, and now I'm trying to rely on it in the suit against the law firm. The answer is the law firm is stuck with what the court decided as to the law firm's client because they're in privity. So anything decided as to the client is decided as to the law firm for purposes of future litigation, whether for good or for ill. That's you accept it in both directions?
Well, you'd have to in the situation here, but keep in mind here you have mere allegations. So what you may be hinting at this, and it goes beyond the scope. Actually,
more general though, counsel. My question's more general. I just want to know: do you agree that the logic of your position? Do you accept that the logic of your position is that if the law firm, if this litigation had been lost, that the adverse rulings in the litigation would be binding against your client, the law firm, even though the law firm was just the law firm, in any subsequent litigation where someone was invoking claim or issue preclusion, because the law firm and the client fisc are the same for purposes of preclusion, for good or for ill.
Right. As to the amounts that went into as the findings of the court, you would be bound by those findings. As to what actually gets into the amount of the judgment, for example, you would be bound.
More than that, though, if it's claim preclusion, it'll be more than what was just actually decided. It could be anything else that could have been raised. I don't know. Maybe one could say, well, the law firm, somebody started raising allegations about the law firm, and the law firm, should have brought, could have brought its own legal action, or anyway, it just seems, I just want to make sure you understand and agree with the idea that this principle, if it is one, means that law firms will be bound by adverse decisions against their clients in later litigation where people are claiming issue and claim preclusion, in the sense that anytime there would be issue or claim preclusion with respect to the client, then by operation of privity, the law firm is on the hook for these adverse determinations. And do you agree that's the logic?
The obvious difference is that the law firm is not a party to the underlying litigation. Ms. Bell was. So the analysis might help you with some indications, but it certainly doesn't say the law firm can't raise any defenses to the extent that something goes beyond just what the amounts or et cetera that went into the actual judgment. Actually, of course, the law firm's not a party to the underlying litigation. So there are some obviously inherent limitations to that analysis.
Well, I mean, it seems to me that the logic of your responses is implicitly to acknowledge that a flat rule that an attorney and the attorney's client are always in privity for claim preclusion, or for preclusion, claim and issue, I guess. It's not a flat rule because it sounds like you're saying, well, that would kind of depend. And it might depend on like what all was being litigated and what the law firm's interests were and whether the connections were such as to make it appropriate to treat them as privies. And if that's the analysis, which seems to be to a degree implicit in your answers, the trial court certainly didn't engage in that kind of an inquiry here. The trial court was applying, as some courts have, just what seemed like just a per se rule. Law firms and their clients are in privity for purposes of preclusion.
Then keep in mind, even res judicata is not a per se rule, if you will. I mean, it has to involve rights or remedies. It has to arise out of the transaction or series of connected transactions out of which the action arose. So there's always conditions. And in this case, you're presented with this unique construct where the allegations are essentially the same. So we have a more clarity than perhaps the potential or hypothetical that your honors may be worried about.
You keep going back to the allegations are the same. The allegations are the same in the subsequent litigation, not in the original litigation that you're arguing these claims had to be brought with. And I mean, that just goes back, let's hit on the points that the limiting principles of res judicata, they have to arise out of the same factual circumstances, right? I mean, I guess that issue was decided in Bell, but you keep referring to the two current complaints and ignoring what was in the underlying action. And I've asked several times and you keep not answering on that point.
The two complaints that are current, if you will, directly attack the amount and the ability to secure the underlying judgment.
So why do you need to even pay it in for purposes of this, this case, other than Bell 1's decision by this court? Why do you even need to pay attention to the complaint Bell v. Fisk versus paying attention to the complaint in Fisk v. Bell in small claims court?
Because they all interrelate, and because you have mere allegations, and this court's already made a finding in August, and to the extent that finding is going to apply for purposes of privity, res judicata, then obviously a lot of the allegations and issues here are already settled, and the issues to be decided by this court for this particular appeal are much more narrowed.
So I understand that the res judicata issues are settled to a large extent by Bell 1, but the privity issue was not addressed at all, and that's what I'm getting at.
That's correct. And this court's going to have to decide whether it's going to apply the straightforward principles of agency and the fact that law firms clearly are agents for their clients in underlying litigation, and whether that straightforward principle applies to this case.
Okay, in terms of agency, are law firms agents of their clients in any regard, even if they're violating a law or alleged to be violating a law?
For purposes of underlying litigation, yes, they would be. There's no exception to that, because then anyone can raise an allegation that a law firm is breaking the law, and you'd have carte blanche to, once again, ignore the finality of decisions and ignore res judicata, because you can just come up with any creative legal theory that, well, the law firm violated this law. And by the way, that was raised in Quick v. Educap, debt collection allegations, recasting the securing of a judgment. That was all raised in Quick v. Educap, and there the court was very clear. It doesn't matter. Res judicata applies, and both are dismissed.
Go ahead, Judge.
That case did not analyze privity.
No, it did not, because all the parties there understood that it was so clear that the counsel and clients are in privity, agent-client relationship. There was no need to get into a privity discussion there. But the underlying principles were, of course, the same.
Again, you keep suggesting that how we answer the privity question will like open law firms to greater liability. And I don't get that as a substantive matter, because your point is only about when the claims need to be raised. If you want to sue a law firm because it's representing a client and it's doing something that you think you can sue it for, nothing in this case is going to say whether you can or can't do that substantively. It's just a question of whether if you don't do it during that litigation, you may be barred from doing it later. So it's all about timing. And in fact, it seems like on the merits of things, if law firms are treated as like agents of their clients and therefore like for liability purposes, it's like if your client is arguing X and you're representing your client in court, well, then you can be sued just like your client. It seems like treating them as equivalents is, if anything, more contrary to the concerns you're raising about liability. So, I mean, you don't think a law firm that represents a client that is taking a position that ultimately isn't vindicated should be treated as though it also did whatever the client did. I mean, there are definitely.
Of course, that's correct.
Right.
So this is every client. Of course, that's correct. But by the same token,
so do you think the law firm is so if a client wants to collect a debt and and a lawyer represents the client in court and asserts legal arguments on behalf of the client, you think the law firm is the debt collecting agent and therefore should be held liable in this under general principle and agency laws for its representation of the client. Is that what I'm getting? Or
No, once again, we're collapsing the law firm into the actual party litigant. And that's not what privity.
I thought your privity argument rested on the idea that we should be doing that.
No, the privity argument is you raised that argument in the context of when you have to sue, and that certainly Rule 14 wasn't raised as far that was raised in the compulsory versus permissive context as opposed to you couldn't have sued. That certainly was never raised on appeal. Nonetheless, but you raised it in the context of, well, she couldn't sue or she didn't sue. Well, then therefore that means she has carte blanche to sue now. It's like, hold on a second here. If the lawsuit is basically raising the exact same allegations against the client and the law firm.
Can I make sure this is, again, Judge McClain has asked this question several times, and the allegation in the small claims action was that Ms. Bell owed money because she entered into a contract to pay it. That was the allegation. And then she owed related expenses. The allegation in both of the two complaints thereafter are focusing for a minute on your clients, that your clients didn't, made false statements in court and a whole bunch of other things that are quite different from the allegations in the complaint in the small claims matter. So they're not identical. Now, what they are is potential defenses that could have been raised maybe in the small claims matter. That's what they seem more like. And maybe potential third-party defenses, or maybe not, depending on how you interpret small claims Rule 14. But they don't seem like they are at all related. Everything is related to everything else in some way. But they seem quite distinct from the allegations in both of the two complaints that were filed after the Small Claims Act matter seem quite distinct from the allegation in the small claims matter was that Ms. Bell owed Fisk some money under a contract.
And the allegations in this case are that Ms. Bell didn't owe that specific amount because of a affidavit that wasn't true, because of amounts that weren't properly assessed. So the two are directly related to each other. The whole allegation here, the only reason this case was even brought is Ms. Bell is saying the amounts are wrong and you couldn't have collected. And that's
that's just inconsistent. Some of those arguments sound like ones that you made and were not fully accepted in Bell 1, because Bell 1 said, no, actually, even as against the original client, some of the new claims are distinct enough that they can go forward because they don't nullify or impair rights, because some of them relate to notice and various other things that are distinct enough from what was the issues that seem to be front and center in connection with the original small claims matter.
In Bell 1, the court was very clear that the only allegations that remain are those that relate to the actual repossession itself and the notice sent in connection with that repossession. Everything after that fact that baked into the dollars and cents is precluded.
As against Fisk.
As against Fisk. And then the question, of course, in front of this court is whether that also equally applies to the law firm. And that's what we're discussing today.
Counsel, you also are well over time. Unless my colleagues have further questions, I want to give you a minute if you'd like to wrap up, and then we'll hear from opposing counsel rebuttal.
Well, thank you for the time. Thank you for engaging. Once again, I just wanted to reiterate that the decisions both by the judges and First Investors and Judge Williams here were clear. They were straightforward, and they applied well-established legal principles in the context of this case. First Investors, every allegation that was brought against First Investors after the repossession, which directly implicates this law firm, were found to be barred and precluded in Bell 1. This court should equally apply those decisions in Bell 1 and find under well-established privity principles and agency that indeed the law firm does not have any viable claims against it now based on the established precedent in Bell 1. Thank you for your time, Your Honors.
Counsel, Ms. Dennis will give you 3 minutes for rebuttal.
Thank you, Your Honor. Just to say, just for the record, all the defendants all the judges that had looked at the Fisk case, that's much easier to say, all of them that looked at that case said that the judgment that resulted from that case was based on breach of the settlement agreement. That's it. That judgment is based on breach of the settlement agreement. So when Ms. Bill did not make payments under that agreement, she was not, the defendant filed for a judgment and it was entered against her based on that. As far as the privity is concerned, and Judge McLeese, I believe you made mention of this, having a per se privity designation for law firms and their clients, that also subjects the law firm to liability with respect to the actual judgment that the client actually receives. So if they have the same interests, if they're litigating the same interest, the law firm is litigating the same interest as the party, which is also a conflict of interest under ethical rules. But if they have the same interests, the law firm could easily not represent the client's best interest, because they're thinking about their own interests with respect to that particular case. And just as I said before, just to conclude, Rule 14, as I said, does not allow Ms. Bell absolutely did not have a fair opportunity, full and fair opportunity to litigate the case. Based on many of the reasons in my brief, as well as I said, as I've argued here, there is no privity with respect to, the defendants have failed to actually prove with evidence that they are in privity with their client. The district does not have a per se privity rule with respect to attorney clients, and the district's jurisprudence with respect to privity and preclusion law is very deliberate, very cautious, and very constitutionally minded. So to have the defendant have say that, to actually rule in this way, it is not the type of privity, a per se privity exception does not fit with the court's jurisprudence on this issue. Basically, as I said before, and the doctrine is, I apologize. As I said, the record is devoid of any evidence proving an agent principal relationship between defendants and FISC and the scope of any agency. A per se principal agent designation between an attorney client for purpose of preclusion that is advocated by defendants is an extreme application of state law preclusion law of the kind that is rejected in Richardson Supreme Court, Richards v. I believe it's Alabama Supreme Court case, and also South Central Bell, and also Taylor. All this type of privity was actually rejected in those cases. A broad-based privity exception based merely on the attorney-client relationship, as I said, is not a discrete exception of the type that is actually mentioned in Franco, as well as in Taylor v. Sturgill. It's a more, as I said, a more extreme version of preclusion law, extreme application of state preclusion law. And for those reasons, the court should reverse the ruling of the trial court. Thank you very much.
Thank you, counsel, but for both sides, and the case is now submitted.
Thank you, Your Honor.
This honorable court is now adjourned.